substance abuse history, some things of that nature that can assist the judge in tailoring the sentence then to each individual defendant.
Sometimes we ask you to reverse engineer things. Go back and look at the last year's cases of meth, heroin, something. I don't even know. Do you use the pre-sentence reports for that?
Years ago, the way the code was written, it was required that a judge either order a pre-sentence report, or if a pre-sentence report was not ordered, DOC would prepare what we called a post-sentence report that would in essence contain all of the same information that was in a pre-sentence report, but not the narrative sections. It would just have all the check boxes and things, standardized information. With that system, we had what represented basically a universal database of felony sentencings in Virginia. About 2007, 2008, DOC stopped doing post-sentence reports. So pre-sentence reports, while valuable in many ways, don't provide us that complete database of felony sentencing information that would allow us to look, for example, the different drugs associated with the events and things of that nature.
But there's really, we're just trying to find a reason not to do. What's so wrong about this? And you're saying it would not impact the work you do? It
would not.
Okay.
It would not.
Delegate Lindsay, so if this one passed, this would seem to be larger than. Okay. I mean, bigger than. Okay. All right. Anyone else in the public? This feels like a big shift, but I can't think of a reason why not to do it. Okay, so.
Mr. Chairman,
Delegate.
I would simply say I don't want to mess with perfection here because I think that's exactly right. Chris Winslow on the Chesterfield County Board of Supervisors and brought this bill to Delegate Lupasi. The one thing I would just note is that the pre-sentence report itself is of, I would say, questionable value. There are some times when it's really valuable. There are some times when maybe it's not as valuable, and I think a competent criminal lawyer will be able to determine whether or not it's going to be valuable in their client's case. That's the only thing I'd add. Thank you.
Prosecutor too. Yeah, that's right. Okay. All right, we will entertain a motion on the bill. So Mr. Cotter.
Mr. Chairman, a couple technical amendments on, we're going to strike out no contest and put in the Latin, because that's what's used in the code.
What is the Latin? I'm only familiar with Noli Prati.
No. Yeah.
Mr. Chairman, I have a technical suggestion just to move the language unless waived by the defendant, and now the language and the current attorney for the Commonwealth to behind the word shall on line 19, shall, comma, unless waived by the defendant and the attorney for the Commonwealth, comma, when the defendant pleads guilty or no contest. It leads to a cleaner read.
Why?
When I first read this statute a couple times, and I think Mr. Winslow had and Mr. Lupasi had the same reaction, it looked like that may have only applied to when they plead no contest. So it looks like not guilty.
I agree. That's right.
So that's why I think that's a suggestion.
Sounds terrible, but you're right. Okay. Is there a second to? Okay. Motion is made to do all that, and seconded. All in favor, say aye. Aye. Opposed. Okay. Motion is made to report. Is there a second? All in favor, signify by saying aye. Aye. Opposed. Okay. Right, he said he doesn't mind rolling his in. Argue about that every year.
Yeah, I've already sent him a co-patron thing electronically.
All good. Well, a motion has been made to table the bill by Delegate Gilbert. Second, all in favor? Aye. Aye. Opposed. All right, Delegate Lindsay, thank you. Is that it for you for the day? Thank you for your time today, sir. All right, I have Bulova, Krizak, I'm sorry, Hoagie to get done, right? Okay. All right, Delegate Pogge, which bill is this? This is 1874.
Thank you, Mr. Chairman. I think that there has been some language crafted that would take care of the understanding of the bill and simplify what the deputies need to do.
Mr. Chair, I have the language
Okay.
prepared. This would be inserted on line 105 of page 2 after 3-day filing period. The new language would read, for the purposes of this section, the warrant will be considered executed in the jurisdiction where the entity on which the warrant is served is located, period.
I'm sorry. Could you read it one more time, please?
Absolutely. This would be on line 105 of page 2 after 3-day filing period. New language. For the purposes of this section, the warrant will be considered executed in the jurisdiction where the entity on which the warrant is served is located.
Okay. Okay. Anybody have any questions for council or the patron? Delegate Alvo.
Have you heard from the, Delegate Pogge, have you heard from financial institutions like the Bankers Association or anything?
No, I have not.
Okay. The reason I'm asking, Mr. Chairman, is if I'm a bank and some sheriff just faxes something to my fax machine and all of a sudden I'm now obligated to answer to it, I mean, if they're not here, they can, I guess that means they don't have a problem with it.
Mr. Chairman,
Yeah.
I would just suggest that this is codifying current practice as I've seen it in a number of jurisdictions over the last few years.
Let me ask Delegate Mullins or somebody else who's done this before. I don't know. So if I serve it on you, I say I served it on you. If I post it, I'm able to say at least the door. How does this work? I send you an email saying, "See attached."
So what normally happens is that there's a designated recipient of service, whether it's electronic or physical. And so each individual business sets up their recipient. And so whether it's by fax, whether it's by email, whether it's by, I guess, by pigeon, that is the one repository for receipt of service.
Albo is the vice president for Commonwealth Bank. I put this in the email and file the service, wherever that was. What how do I know that he got it? What happens if he doesn't respond?
Well, I mean, the method is still a show cause that you could always still have. But normally the way that you'd have to follow up. I think that there's an impetus on the person who was originally seeking the warrant.
Delegate Albo.
It would be better if the bill said at the accepted method or accepted fax number or accepted email for the institution. Because this thing says now you have statutory ability to serve a search warrant on a clerk's fax machine at a remote bank nowhere near where the records are kept.
Delegate Albo, now you can just throw the mic down. Just mic dropped. No, I mean, you could do the same. You could walk into a remote bank office and serve the teller. Right. So the Commonwealth's attorneys here. I mean, so I mean, the question is, I get a teller's name. So I send this in. I do this. I send an email or fax or something to someone, and 2 weeks later, whatever, nothing comes back. I mean, I never saw anybody, never heard it from anybody, never talked to anybody on the phone that I could identify.
And Mr. Chairman, to reiterate what Delegate Mullen has said, that this is basically codification of standing practice. Most of the time, it's already a telephone conversation. I can't imagine when there wouldn't already be a telephone conversation. Hey, we want this particular information. They'll say, fine, send me something. I need a CYA. something, send me something, great, I'll send it to you, expect it. Now, we don't go in with a search warrant and rummage through all their financial records looking for it. They're doing the actual search. And we're saying, here's the document, we've had this conversation, expect it the next day or two. It goes to that particular person, and then, you know, within 2-3 days, it comes back, and off you go. And if we don't get it within 2 or 3 days, you call them back up and say, hey, did you get this? And they say, yes, I did, no, I didn't, I'll respond in such and such a time.
Okay. All right.
May I say something?
Delegate Bogey.
Yeah, and I just want to make sure that what the bill is going to do now is not extremely different from the original bill, in that what the Sheriff's Association was wanting was to eliminate a requirement that the copy of the warrant be filed where the warrant was issued for all search warrants, so that we didn't have the two different copies in different locations. So does the new bill that we're, or the bill that we're amending now, will it accomplish the same purpose on behalf of the Sheriff's Department?
We haven't changed any of that.
Actually, I wanted to address that first section as well. If you look at 19257, the last line of that statute allows the sheriff's deputies to file by mail or by fax. So if the issue is they have to drive very far, I think that 19257 takes care of that. To say that you don't, that it still can be filed in the other jurisdiction by mail or by fax. And just to point out that it's the affidavit that needs to be filed in the other jurisdiction. The warrant itself only needs to be filed where it's executed.
All right. Anybody else want to be heard on this bill? What is our pleasure on the bill? Motion is made to report. Is there a second? Second. All in favor of reporting the bill as amended, signify by saying aye. Aye. Opposed. Okay. We have Bulova, Krizak, and then Campbell. What's your bill?
Very good. It is 1765.
Tell us the problem, tell us what your bill does to fix it.
Perfect. Thank you very much, Mr. Chairman, and all the members of the subcommittee. As the chairman, just what I had mentioned, I think the easiest thing for me to do is kind of go through the fact pattern as Chairman Alba would go ahead and say that brought this bill to my attention. After that, I do have with me a constituent, Forrest Keisel, who wanted to provide a little bit more personal background about how this problem with the law has affected his family. We do have a substitute that makes one small change that was brought to our attention by the governor's general counsel, and I can explain kind of what that does at the end, but I think it's a friendly amendment. During the end of 2014 and into early 2015, Mr. Keisel's daughter was repeatedly assaulted from a bodily standpoint. She was also the subject to attempted blackmail. When she turned to her parents for help, Mr. Keisel confronted that individual. At that time, the individual then proceeded to assault Mr. Keisel in front of his wife and his daughter. The police were called. The individual was arrested. He was tried. He was found guilty in Fairfax County General District Court, and he was ultimately sentenced to 2 months confinement and 10 months of probation. So all good news. The system of justice seemed to be working well in this case. As was this individual's right, he went ahead and appealed the case to circuit court. And as you all know, once you do that, you start that as a de novo trial. So all good so far. To the dismay of the family, though, the individual never showed up. Didn't show up in court, never contacted or communicated with the court. And so while an issue or a warrant was issued for his arrest, what you end up with is an untenable situation where you have a person who was convicted in General District Court, and is now free, whether in Virginia or absconding to another state, and technically he's not guilty or convicted of any crime. That struck my constituent as being wrong. It struck me as certainly being wrong, and that's why I went ahead and introduced this bill. I had a chance to sit down with my local clerk, John Fry, who I believe is still president of the Clerks Association, and also my Commonwealth's attorney, Ray Morrow, who both agreed that this was an issue, it was a real problem. They took a look at the language that's before you today. And I also had a chance to sit down with one of our judges up in the circuit courts just to get a sense of, was this actually a real problem? And he said, yeah, it really is a problem. And so it's from two standpoints. One is the administrative aspect of just these cases remaining open, but he also saw this as a real issue with respect to victim justice. And what he was saying is that this doesn't just happen with assault and battery. This is also a case for DUI. This is also a case where you've seen it in stalking cases and so on. And so all I'm trying to do with this bill, Mr. Chairman, is make sure that two wrongs, and so somebody is convicted of a crime in general